when you can advise when we are live.
Okay. Good afternoon, Minister.
Good afternoon, Ignatius. Good afternoon, Michael.
Afternoon, Minister.
Hello, Malebo, DG. Takalani Pumzile. Hello, Evelyn.
Good afternoon, Minister.
Good afternoon, Minister.
Afternoon, Minister.
All right, I think DG is over to you now, and I believe that we are ready to start.
Okay, correct. Just a minute. Thank you, everyone, for making the time to come to the media briefing today. We will today be dealing with the briefing on the company's amendment bill, and I'm going to immediately just ask the minister to give us his brief remarks, and then we will take it from there. Minister Patel.
Well, first, thank you very much, Director General, and good afternoon to members of the media who are present at this briefing. On Friday this week, government will be gazetting a draft bill proposing a number of amendments to the Companies Act. The bill will be published for public comment. I want to briefly sketch the background to the bill, then summarize the core policy objectives that it seeks to address. I'm joined today by Professor Michael Katz, who is the chairperson of the Specialist Committee on Company Law, which is a statutory body set up under the Companies Act. And we're also joined by a number of members of the committee who I wish to warmly welcome. Following my remarks, I will ask Professor Katz to address a number of the technical amendments in the Companies Amendment Bill. So let me start with the background to the bill. In 2011, the Companies Act came into effect, the amendments that were made to the previous legislation, and it represented quite substantial changes to the policy framework applicable to corporate governance matters. 5 years after implementation, there was a planned review of the impact of the Act, and that resulted in a number of areas where technical changes were required, essentially to give better effect to the purposes of the Act. All of that work resulted in a decision in 2018 by the department to publish a bill setting out proposed changes based on the work of the Specialist Committee on Company Law and the views of stakeholders. The notice that was issued at the time requested comments from the public, and the department was heartened. It received a number of suggestions and comments, and these were extensively then discussed thereafter with the representatives of organized business, namely BUSA, and organized labor at NEDLAC. And in that process at NEDLAC, further changes were proposed. When I received the final report, I recognized that given the extent of the changes, it would be desirable and appropriate to have a further opportunity to obtain public comment, and that we do so before the bill is finalized within the executive. Cabinet discussed the matter 2 weeks ago and agreed that the bill be released for a 30-day comment period. After the comments are received, so just talking what happens from this Friday, we anticipate that the bill would be published by the government printers in the Government Gazette. 30 days would elapse, and in that period, members of the public can make comment. After the comments are received, they'll be evaluated, and if warranted, changes will be made to the bill, and it will then be considered by Cabinet. After Cabinet approves it, the bill will be sent to the Speaker of Parliament, who will table it for consideration by Parliament. So that's really the background to the bill that we're talking about today. I want to now go to the content of the bill and start by saying that there are three key policy objectives that the proposed amendments seek to address. The first area addresses the ease of doing business. In this regard, it's important that company law should, among other factors, be clear, be user-friendly, be consistent with well-established principles, and not be overburdensome on the conduct of business. This is, of course, important not only to attract foreign investors, but also for the efficient and effective conduct of the domestic economy and for the creation of jobs. As members of the media will see from the explanation set out in a briefing note to the bill that will be gazetted, in respect of many of the proposed amendments, they're technical in nature, they're based on submissions received during the extensive engagement with interested parties, and they are designed to ease the doing of business through providing legal certainty where that does not currently apply, through providing greater flexibility to companies in certain circumstances, or by removing unnecessary provisions in the Act. As I indicated a few moments ago, Professor Michael Katz will be taking us through a number of these changes. So I'm going to identify that area as quite important, and I will, in a few moments, hand over to Michael to lead us on that one. The second area deals with excessive pay policies in companies. The bill seeks to clarify the responsibilities between directors and senior management on the one hand, and shareholders on the other hand, as well as addressing public concerns regarding high levels of inequality in society. Excessive remuneration, particularly at the highest level of a company, is a matter of great concern internationally, but also in South Africa. During the course of discussions on the bill with both BUSA and with organized labor, the matter of wage ratios and the status of remuneration reports were raised and a number of proposals were made. The discussions focused on what would be an appropriate package of measures that would provide for disclosure of information, coupled with greater rights for shareholders at annual general meetings in respect of remuneration reports, without placing an undue burden on smaller businesses. Based on the outcome of the discussions with representatives of business and labor, amendments were drafted for inclusion in the bill. I'm going to speak briefly to it. The bill requires that publicly listed companies and state-owned companies disclose information on the pay gap between directors and workers in their annual financial statements and annual reports. The bill also provides that where remuneration and benefits are received by company directors or prescribed officers, such directors or prescribed officers must be named in the annual financial statements. It's limited, this particular provision, it's limited to companies that are required in terms of the current Act to have financial statements audited independently. Research presented in the discussions that was held at NEDLAC showed that it's a common practice in a number of jurisdictions to require disclosure of remuneration for specified senior executive positions. The bill also provides shareholders with better tools to respond to how remuneration issues are dealt with in companies. The bill proposes the insertion of a new section obliging public companies and state-owned companies to prepare and present a director's remuneration report for approval by the board of the company. The remuneration policy should be presented at an AGM for approval by ordinary resolution. Once approved, such policy would only have to be presented every 3 years whenever there's a material change that is made. Should a remuneration policy not be approved at an AGM, it must be presented at the next AGM until approval is obtained. And changes to the policy may only be implemented once shareholders approve it. Companies will now also be required to publish details of their highest paid employee, their lowest paid employee, their average remuneration, the median remuneration, and the gap between the top 5% highest paid and the bottom 5% lowest paid employees. The pay gap has been a historical challenge in South Africa and a contributor to the country's high levels of inequality. Following this proposed amendment, the intention is the Act would allow for stronger shareholder governance on excessive director pay, and for company shareholders and stakeholders to be aware of, and if necessary, address unsustainable pay discrepancies. I need to point only to the many instances in the last year and a half, 2 years, of enormous shareholder disquiet to show why a change like this warrants consideration. The explanatory memorandum that we're publishing provides for some of the publicly available information on wage gaps, and it makes the point that the kind of inequality underpins much of the well-known workplace conflict in South Africa. The proposed publication of indicators of pay differential will empower shareholders and other stakeholders to see trends and, where warranted, propose changes. Of course, there are complex considerations on the appropriate pay regime that should apply in a particular company. And due note should be taken on the need to attract and retain the best skills for domestic firms. For that reason, the bill does not seek to propose what the ratios between executive and worker pay should be. That's not the proposal in the bill. Instead, it proposes transparency, that the information be known, and it empowers shareholder voting to be more effective than it currently is. There's no question, however, that there is widespread public concern about existing pay practices in some firms and with the current regulatory regime. I know I'm speaking to a number of media outlets, but I think it's very well summarized by a recent Business Day editorial. So permit me to quote from it. They put it rather bluntly. They said, and I quote, "It is common knowledge that the wage gaps in South Africa is a yawning one. This is mainly a product of South Africa's apartheid history, which elevated the salaries of white executives to stratospheric levels, as well as a response to a skill shortage at executive level. The market for executives is a global one, and to attract skills, South Africa has to remain competitive. And once a norm within the market has been established for executive pay, it tends to reproduce itself by creating expectations." So that's the commentary in the public domain. Both the business and labor representatives at NEDLAC support the proposals in the bill on the publication of wage ratio information and the presentation to shareholders at the AGM, with the exception of a few specific details, and I'll just briefly summarize them. I'm sure members of the media would be interested in them. First, as regards the vote on the remuneration implementation report, BUSA supports the formulation that government has put in the bill. Labour takes a different view. Labour proposes that the vote should have the status of a special resolution, with 75% of shareholders having to approve the report, instead of what the bill provides, which is that it's done by means of an ordinary resolution requiring 50% shareholder approval. So the bill says the test really is that you get a majority, 50% plus one of the shareholders voting in favor of it, and then it is approved. That's supported by business. Organized labor says they would prefer to have it as a 75% threshold of approval. The second area that was not finally resolved in the discussion regards the basis for the calculation of the ratio between the highest and lowest paid. Both business and labor supported the principle of disclosing the wage differential. No difference of opinion there. And they also agreed that the appropriate ratio be used, namely the top 5% and the bottom 5% in a company. And the issue really is around the definition of remuneration, whether you include all remuneration or what is called on-target remuneration that takes away the peaks and valleys caused by payments of certain bonuses. And that, of course, is an important area to clarify, but it's really in the detail. The provisions relating to transparency on the pay gap and the reasonableness of remuneration will then provide an objective benchmark which will assist the public dialogue on this topic. So while we've not set out what the ratios should be, we think a more informed public conversation and discussion on this would be enhanced, would be supported by the transparency that the bill seeks to introduce. That brings me to the third and last area, and that relates to efforts to counter money laundering and the financing of terrorism. South Africa is part of an international effort by leading economies to address these concerns. The Group of 20's global framework for tracing beneficial ownership requires members and affiliated countries to encourage beneficial owner disclosure in all their legislation governing business and investment institutions. Hence, government has adopted the G20 high-level principles and beneficial ownership transparency as far back as October 2015 to prevent misuse of juristic persons and legal arrangements of ownership. Establishing and disclosing true owners of companies will increase transparency, including in public procurement, and it will allow government and the public to monitor government procurement spending. South Africa's rating in the mutual evaluation assessment of the country's anti-money laundering and combating the financing of terrorism pointed to weaknesses in determining the true owner of shares in companies. To address this, the bill sets out proposed amendments relating to disclosure of ultimate beneficial ownership in the shares of a company. Government's efforts to counter money laundering and terrorism feature not only in the proposed amendments to the Companies Act, but we're also looking at other areas of legislation and administration. Again, I make the point that these concerns are being addressed in many foreign jurisdictions. The bill adds a new definition of true owner to enable us to achieve the objectives I spoke of. A true owner is defined by the proposed amendments as a natural person who has the power to direct the registered holder of a share with regard to the share who ultimately benefits from the shareholding. In terms of the proposed definition in the amendments, only a natural person can be a true owner. The identification of the true owner is part of the broader objective of identifying the holder of beneficial interest in the company. The bill proposes several amendments to sections of the Act in an endeavor to identify the true owner more effectively. The remainder of the proposed amendments that will be in the bill do not fall within these three prime categories of policy objectives that I've spoken about, as they are essentially purely administrative issues or the enhancement of regulatory efficiency or the tidying up of drafting deficiencies. So to sum up, there are three policy areas we seek to address. We have engaged actively as government with a number of stakeholders, as well as with the parties at NEDLAC and with the committee that Professor Michael Katz chairs. And what we've looked for is a balanced set of proposals that does take account of the policy objectives, but does it as smartly as possible. We've had broad support from both business and labor to the package, with the exception of a few modalities that are noted and identified. And we're releasing this on Friday to provide the public with an opportunity to comment. And of course, we really would encourage comments on any part of the bill, but in particular, there are four areas that would be enormously helpful to get a set of comments and the views of the public. The first is the extent to which the bill addresses the concerns raised in our previous public consultation process regarding gaps and challenges experienced by practitioners following the review of the implementation of the Companies Act. So we want to make sure that that first process, we've captured all the key things and nothing has fallen through the cracks. Obviously, it's not the same as agreeing with every representation, but just to say, have we captured those areas adequately? The second is whether and how the changes that are contemplated in the bill, taken as a whole, will impact on the ease of doing business and the objective of eliminating unnecessary red tape. We recognize as government that regulation is necessary, but it's got to be smart. Try to make it as simple, as clear, and as minimal as possible in relation to the objectives that should be achieved. Have we got that balance right? And if we don't have that balance right, members of the public may be able to point us to simpler, better ways to achieve the public objectives that we're seeking to achieve. The third question is the proposals on greater transparency on pay gaps and the power and responsibilities of shareholders and directors in this regard, as well as the specific mechanisms to deal with these issues, as I have indicated. So we're keen to get feedback on that. And finally, we would value feedback on the new provisions on beneficial ownership in light of the global effort to address anti-money laundering and financing of terrorism, as well as on appropriate triggers for disclosure and the content of the disclosure. So I've taken what is quite a significant set of changes to the Companies Act and given it a rather broad brush summary here. I would like now to hand over to Professor Michael Katz, who is not only considerably more knowledgeable, but would be able to take members of the media through, in particular, those changes that have been made to improve the effectiveness and efficiency of the Act and enhance the ease of doing business. As I indicated, Professor Katz is the chairperson of the Specialist Committee on Company Law, and we have other members that we are most grateful could join us today in the session. Professor Katz, may I hand over to you?
Thank you, Minister. Firstly, I disavow any excess knowledge or expertise. Secondly, thanks to you for your cooperation, working together with you and your colleagues on achieving this amendment bill. Secondly, thanks to the DG for her presence. And a special thanks to Evelyn Masocha. Evelyn worked tirelessly with the Specialist Committee and phoned me after midnight, weekends and all. So it's really appropriate that we record our gratitude to Evelyn for her efforts. Then I want to thank my colleagues on the Specialist Committee. This was a team effort, so thanks to them. And now thanks to members of the media for hearing us. The Minister has very eloquently covered the whole background, covered the issues, and covered two of the three philosophical pillars. I'm going to try to deal with the third one, the ease of doing business. And the Minister has emphasized the importance of user-friendly, clearly understood legislation. There is a great attention in the world today to lower the cost of compliance, lower the cost of administration, and these were all objectives that one sought to achieve in totality, but in particular in some of the important technical amendments that I'm going to try to explain. And in reducing burden, yes, it was intended to reduce the burden of compliance for everyone, but there's certain specific attention to small and medium business, where the burden of compliance is even more difficult than for the rest of the community. So against that background, I'm going to quickly try to take you through some of the more important technical amendments. Firstly, on the face of it, a small one, a new definition of securities. The old definition of securities, which referred to shares, debentures, and other instruments. And it was very difficult in practice to determine what another instrument was. Was it a shareholder's loan account? The definition is now to be limited to shares and debentures. Another very important one is the giving of certainty in terms of the amendment to section 16 of the effective date of amendment of an MOI. This has been really a very difficult, uncertain factor in doing business, that people have not known the effective date of an amendment to the MOI. It will now be the 10th day after the receipt by SIPC of the amended MOI, or a later date, but not an earlier date. A later date as set out in the amendment itself. Then another important amendment, and I'm not doing it in any chronological sequence, I'm just taking a sample by way of illustration, is section 45 of the Act. Firstly, the title of the section in its present form is confusing. It refers to financial assistance, intra-company, but it deals with two issues. Financial assistance by companies to directors and prescribed officers, and intra-group financial assistance. And where there is intra-group financial assistance, it necessitates the approval by a special resolution passed within the last 2 years, approved by the shareholders. Now, this was unnecessarily wide, and I think unintentionally wide, because it also included in the net the giving by a company of financial assistance to its subsidiaries. This served no rational purpose. It was burdensome and really retarded the doing of business. So an amendment is proposed to section 45 to eliminate or to take out of the net the giving of financial assistance by a company to its subsidiary. Then there are a number of amendments to section 26, which deals with the information that stakeholders are entitled to from a company, and the amendments here are designed in particular to reduce the burden on small and medium enterprise. So too, section 33, where a company has to file its annual financial statements and has to include its certain financial statements and other reports in that. Here, again, in the case of small and medium enterprise, it was unnecessarily burdensome, and appropriate changes are being made, and also consequential changes for the two important areas that the Minister has spoken about, the remuneration report and the register of beneficial interests. Those will now be encompassed as well. Then an important amendment to section 38, rather the insertion of a new section 38A. Again, unwittingly, a provision that existed in the predecessor Companies Act that permitted an application to court to remedy an unlawful, authorized creation or issue of shares. For example, where a company issues shares beyond its authorized capital. And this has proved very troublesome in practice, and the proposed amendment will close this lacuna and allow an application to court for the appropriate remediation, and the court will be empowered to impose appropriate conditions. We then get to Section 40, and Section 40 is a provision in the Act that allows a company in certain circumstances to issue partly paid shares. This is a total exception to everything else. And what this facilitates, the structuring of empowerment transactions, for example, or earnings by allowing shares to be issued and paid off over time through dividends. The deficiency that exists in the current Act that sought to be remedied in the new Act is that until the shares are fully paid for, they were required to be held in trust. And that caused confusion. Did it mean that the Trust Property Control Act would apply to those provisions? And this is now being replaced. Not that they will be held in trust, but they will be held by a stakeholder. Another important amendment in practice is when a company buys back its own shares. And in terms of the existing Section 48.8, read together with 48.2, where a company buys back, proposes to buy back more than 5% of its issued capital or of a particular class of shares, then it states that the provisions set out in Section 114 and 115 applicable to schemes of arrangement will be required to be complied with. Now, this really has proved a huge burden, created huge uncertainty, and unnecessarily so. The proposed amendment is that the special resolution contemplated in Section 48.8 will not be applicable in respect of shares bought back where the shares are traded on a recognized exchange, or where it's done as a pro rata offer to all shareholders. And interestingly enough, even if the holders of shares in that pro rata offer are directors or prescribed officers, the requirement of a special resolution will again be dispensed with. If, however, the offer is only made to directors or prescribed officers, it will need the special resolution. Then, as the Minister has mentioned, there are some significant qualitative amendments to Section 56, which deals with beneficial ownership. And then we look at some amendments to Section 61.8, which deals with the annual general meeting. And there were deficiencies up to now as to the appointment of the Social and Ethics Committee and various other things that should have been provided for to happen at the AGM and didn't previously. That is now being remedied. Another extensive set of amendments are to Section 72, and that's the Social and Ethics Committee. And there, the content of the report, the companies to which it will apply, and the process for the report being placed before shareholders and being required to be approved by shareholders, and the consequence of not achieving approval are all set out in the proposed section 72. The next important amendment is to section 90, and that relates to the appointment of auditors, and the small and medium enterprise are not, those that aren't required to have financial statements, audited financial statements, won't be required to have an auditor. An important change. Then in section 92, the cooling off period, where a company wants to appoint an auditor, and there are disqualifications because the proposed appointee has been involved in non-auditing work in that company during the last 5 years. This has proved very burdensome, particularly with the changes to the Audit Profession Act requiring mandatory audit firm rotation. So the cooling off period referred to in section 92 of 5 years is proposed to be reduced to 2 years. The second last one, Minister, if I may quickly deal with, is section 118, and that is the application of the jurisdiction of the takeover panel. It applies to public companies, state-owned, and to certain categories of private companies. And the provisions defining which private companies it currently applies to are hugely overburdensome, and once again, unfortunately, without any rationale. So there is a significant amendment proposed to the definition of a private company in order for it to be a regulated company, and that is going to have much more rationale. It will be on public interest scores, essentially determined by the minister in consultation with the panel, based on the turnover and the company. Last one that I'd like to mention of importance is the amendment to section 135, which deals with business rescue. As you know, the policy of the legislature is really to make business rescue a viable alternative to liquidation, to preserve jobs, to protect jobs, and really liquidation should only be the ultimate. So the preferred route of the legislature is business rescue. Now there's been again, it only manifests in practice. When a company goes into business rescue, it places a moratorium on the ability to institute legal proceedings. So a landlord has a tenant in business rescue, and the contract provides for the tenant to pay for water, electricity, rates, etc. The tenant doesn't pay, and the landlord can't institute proceedings because of the moratorium, so the landlord has to do so. And the new provision, or the proposed amendment, makes the payments in these circumstances by the landlord equivalent to post-commencement finance. And it will rank in post-commencement finance, but after the preference of employees. So always the preference of unpaid remuneration comes first in the ranking in business rescue, then post-commencement finance, and this new species of post-commencement finance will rank with the other post-commencement finance. Minister, I think that's a sample, and I really extended my time way beyond what was allocated. My apologies.
Thank you very much, Michael. No, I think that was very, very helpful. May I hand back to the DG? Over to you, DG.
Thank you, Minister. And now we are at that point where we would take questions from members of the media. May I ask that for anyone who has a question, if you can please identify yourself and then also the media house from which you come, and then only after that raise a question. And I'm going to also ask that we limit our questions to the subject matter of interest for the day, which is this amendment bill. Any other questions, we of course remain available to deal with that, but outside of this process. I'm not sure if there are any questions already. Bulelani, if there's anybody with a question?
Nothing at the moment, DG.
Thank you very much. Any questions from our colleagues from the media? Or was it very clear? I'm just waiting for an indication of any hands. Bulelani, I see there is one.
This is one from FIN24.
You can go ahead.
Yes. What is the rationale for having pay gaps declared? And will it improve business competitiveness?
Given that that is the only question we have at the moment, Minister, I'm going to hand over to yourself. Thank you, Minister.
Well, first, thank you, and good afternoon, Lamis, to you. So perhaps I should break it into its two components, the questions that were asked. The one is the rationale, and the rationale is, first of all, to provide for a more informed public discussion. There is significant public disquiet, sometimes in the ranks of shareholders, at other times within the public domain and commentators. And there's at times a paucity of comparable data. So a company may make the point that its differentials, while large, may be in line with what companies elsewhere are paying, and that it reflects the challenges of attracting and holding onto scarce skills. When one has an objective benchmark of information that can be evaluated more objectively, more dispassionately, and the public discussion can be enhanced. So that's quite important. The second part of it is that shareholders themselves often have enormous disquiet about the executive remuneration policies, and for shareholders to have objective, verified information available can also enhance their role in determining what should be the appropriate remuneration policies within a company. So if a company decision-making at an annual general meeting is in the hands of shareholders, the question is, on what basis do shareholders make that kind of decision? Providing for greater disclosure, in our view, would enable shareholders to exercise their rights and responsibilities in a more informed way. So the one is for the broader public discussion, and the other part of it is to enable shareholders to carry out their own responsibilities as they see fit. The next question is, will it enhance our competitiveness? One of the big challenges in building a dynamic and competitive economy is in many instances, lack of cohesion between key stakeholders within a firm. You need a high degree of cooperation between managers and workers to ensure that South African firms are competitive, that they are able to produce the products within the speed and at costs that consumers need. Now that requires that relationships are not simply transactional. They're not only defined by the narrow short-term calculation. There is a greater sense of building together, that we're in this together, that when a firm fails, it's not just shareholders who lose, it's not just managers who lose, it's all workers in that company. Now, when we have tried to foster processes of greater cohesion, more partnerships and so on, one of the matters that's come up consistently is disquiet and unhappiness about remuneration policies. Providing for greater disclosure ought to assist in that. And it can then enable, and maybe this is the third category, a proper conversation even between stakeholders in a firm on these kind of matters. And the objective would be to get South Africans or companies based in South Africa to work more closely between the different internal stakeholders, workers, managers, and shareholders. If we achieve that, and the extent to which we achieve that can significantly enhance our competitiveness. I want to recognize, and I made this point in my opening remarks, that executive pay is a complex issue. It's not a matter that can simply be reduced to a given ratio that applies in all sectors at all times for all kind of skills, needs that companies may have. In the absence of such simple and simplistic solutions, which we don't think is appropriate to simply regulate something like that, the appropriate public policy response is to foster transparency. And tied to transparency is also empowering shareholders. You would have seen as members of the media the concerns that shareholders in a number of companies have expressed through their voting about remuneration policies. But other than the unhappiness that I expressed, there's not always a set and effective follow-through. The proposals that we're putting out for public comment would be an example of the kind of follow-through to shareholder unhappiness, and we look forward to receiving comments on whether the mechanisms are the appropriate ones and whether the drafting has captured it both simply with no unnecessary burden on companies and at the same time that it smartly meets the public policy objectives. I hope, Lamis, that answers the question. Back to you, DG.
DG, may I make one very quick observation?
Please.
The Minister has very well stated that the proposed legislation is merely one of disclosure. And I just want to highlight that because it really is that philosophy of regulation by disclosure flows through almost the entirety of company law regulation in South Africa. So this regulation by disclosure here, as opposed to prohibition, is consistent with a lot of the other provisions in the Act. For example, disclosure and prospectuses. Anyone's allowed to offer shares in any company. You offer it to the public, they can do what they like, but they must make an informed decision, proper disclosure. So what's happening here is part of the same regulatory philosophy, disclosure.
Thank you, Prof, and also thank you to the Minister. I'm not sure if there are any further questions.
Nothing on my side.
Okay, all right. I think with that, then we would take it that members of the media, like many members of our community, are going to take this bill, read through it, look at some of those questions the minister had asked, and assist us in putting together a bill that will help us, as Lamez has said, to continue to have a corporate governance system that works for us and improves our business environment such that our businesses are more competitive. So with that, let me thank Minister Patel, Minister of the Department of Trade, Industry and Competition, Professor Michael Katz, and the members of the specialized advisory council that assisted us here, or advisory committee, and also my colleague, Deputy Director General Masocha, who was also instrumental in putting this together. This is the beginning of conversation, and I'm sure in a very short time, we will be coming back to you with a more final bill that will then be taken through the different processes as Minister had outlined at the beginning. So with this, thank you also to the members of the media. This will then bring this news conference to an end. I see before I concluded, there is a question there. Is 30 days consultation period sufficient? Can't it be extended given the importance of the matters at hand? So I apologize, Minister, I was closing, but I thought it is an important question that we do need to reflect on. So over to you, Minister.
Well, thank you very much, DG. I think, these issues are always something where one has to make a judgment call. I want to recall that we published a bill in 2018, and that bill went through very significant and detailed public consultation, and there was an opportunity for public comment to be made. At the end of that process, typically what a member of the executive would do is consider all of the public representations, make a judgment call on the ones that are appropriate to be incorporated in the bill, and which ones won't make the cut, and take that to Cabinet. Cabinet would then make a decision on the bill, and if Cabinet is comfortable with the bill, it goes to Parliament. We have, somewhat unusually in these processes, we've opened a second window before we take it to Cabinet. This is now over and above publishing the original bill in 2018. And we've done so because in the process of public consultation, matters that I deemed to be sufficiently significant were raised, that instead of simply saying, well, we've ticked the box, we had the consultation, and I've now had a reference to all of that and made a judgment call, we felt it's appropriate to go back for public consultation. Now, 30 days is over, and we've had the comments. We'll take a bit of time to reflect on it, and we'll take it back to Cabinet. If Cabinet approves it, with whatever changes are made as a result of this additional process, it goes to Parliament. In Parliament itself, the Portfolio Committee will have public hearings, or will have an opportunity for the public to make representations on the bill that would have gone through the Cabinet process. So that would be a third window that would open up for public comment. So to sum up, 2018 was quite a significant window that led to a number of changes. Departing from the tradition, we took the view that it would be good to recommend to Cabinet that instead of considering the bill for approval, that Cabinet provides for a second window, which Cabinet agreed to and so decided. This is the second window. Once this window is over, there will still be a third window which is members of the public are of course entitled then to comment further to the Portfolio Committee in Parliament as and when the bill is considered by that committee. So in all, one has to find a fair balance between proper inclusive consultation and at the same time moving the policy-making process forward. Thank you very much.
No, thank you, Minister. Now, I think owing to time, we will have to close at this point. And as I had indicated, thank you to everybody who has been present here and for those questions that you have posed to us. We are looking forward to a very active engagement by yourselves and also by the members of our society in order to help us craft this bill. With that, this will then bring us to the end of this media briefing. Thank you very much. We are adjourned.
Thank you, Director General. Thank you, Professor Katz, and thank you to the members of the
recording stopped
of the committee who are present here today, and to members of the media. Cheers, everyone.